Most people think probate is just paperwork. It isn't. Probate is a court-supervised legal process that can freeze your family's access to everything you own for months, sometimes years, while attorneys, judges, and administrators take a percentage of everything you worked your entire life to build. And, depending on which state you live in, that percentage can be devastating. In California, a $500,000 estate can lose over $26,000 in mandatory fees alone before a single dollar reaches your family. In Florida, that same estate can cost your family $12,000 to $32,000 and take up to 18 months to distribute. In New York, attorney fees run $350 to $600 an hour with no cap and no end date in sight. These aren't edge cases. This is how probate works every single day across America. In this video, I'm going to walk you through exactly how the probate process works, step by step, and why families in California, Florida, and New York face some of the highest costs and longest delays in the country, and what you can do about it before it's too late. Let's start from the beginning. What actually happens when someone dies and their estate goes into probate? Step 1. Filing the petition. The executor named in the will, or a court-appointed administrator if there is no will, files a petition with the local probate court. In California, this filing fee alone starts at $435. In New York, it ranges from $45 to $1,250 depending on estate size. This opens the case and gives the court jurisdiction over everything the deceased owned. Step 2. Appointment hearing. A judge reviews the petition and formally appoints the personal representative. This requires a court hearing. In backlog counties, Los Angeles, Miami-Dade, Manhattan, getting a court date alone can take 2 to 4 months. Step 3. Inventory and appraisal. The personal representative must create a complete inventory of every asset in the estate: bank accounts, real estate, investments, vehicles, personal property. In California, a court-appointed probate referee appraises all non-cash assets for a fee of 0.1% of their appraised value. A $600,000 home generates a $600 appraisal fee on top of everything else. Step 4. Notifying creditors. The estate must publish a notice in a local newspaper, yes, a physical newspaper, alerting potential creditors to make claims. This costs between $200 and $700 and triggers a mandatory waiting period of 4 months in California. During this entire time, the family cannot distribute a single dollar. Step 5. Paying debts and taxes. Before any beneficiary receives anything, all outstanding debts, final income taxes, and estate taxes must be paid from the estate's assets. The personal representative is legally responsible for ensuring this happens correctly. If they make a mistake, they can be held personally liable. Step 6. Final accounting and distribution. The personal representative files a detailed final accounting with the court, every dollar received and spent. The judge reviews it, approves it, and issues an order of distribution. Only then can assets be transferred to beneficiaries. From start to finish, in a straightforward, uncontested estate, this process takes a minimum of 9 months in most states. In California, it regularly takes 12 to 18 months. In contested cases, 2 years or longer. And every month it continues, it costs money. Now let's look at the 3 states where probate hits hardest. California. California has one of the most expensive probate systems in the United States. Attorney fees and executor commissions are set by statute, meaning they are non-negotiable, and calculated on the gross value of the estate, not the net value. Gross. That means if you own a $700,000 home with a $500,000 mortgage, California calculates fees on $700,000, not the $200,000 in actual equity. The debt doesn't matter. The statutory fee structure is 4% of the first $100,000, 3% of the next $100,000, and 2% of the remaining value. And here's the part most people miss. Both the attorney and the executor are each entitled to that fee, so you pay it twice. For a $500,000 estate, that's $26,000 in combined statutory fees, before court costs, publication fees, appraisal fees, or any extraordinary service charges. For a $1 million estate, that's $46,000 in combined statutory fees alone. Here's what that looks like in practice. A family in Los Angeles lost their father in 2023. He owned a home valued at $850,000 with a $400,000 mortgage remaining. His net equity was $450,000. California calculated probate fees on the full $850,000. Combined attorney and executor fees came to $38,800, plus court costs, appraisal fees, and publication notices. The family waited 16 months. They received less than they expected because the fees were calculated on what the house was worth, not what their father actually owned. California also has some of the most backlogged probate courts in the country. The full process regularly takes 12 to 18 months, and complex estates routinely run 2 years or longer. The one piece of good news: estates under $208,850 as of 2025 may qualify for a simplified small estate affidavit process that avoids full probate entirely. Florida. Florida's probate attorney fees are based on reasonable compensation rather than strict statutory percentages, but the costs are still substantial. For most estates, total probate costs run between 3% and 8% of the estate's gross value. Attorney hourly rates run $250 to $500 per hour in 2025. Florida also has a mandatory creditor waiting period. Creditors have 3 months from the date of publication to file claims, and the estate cannot be distributed until that window closes. For simple estates, Florida probate takes 6 to 18 months. Florida also has no transfer on death deed for real estate, meaning property cannot be transferred outside probate without a living trust or joint ownership. For the millions of retirees in Florida who own homes, this is a critical planning gap that most people discover too late. A retired couple in Tampa found this out when the husband passed away. The home was in his name alone. Despite a valid will leaving everything to his wife, the house went through full probate, a 9-month process that cost the family $18,000 in attorney fees before the wife received clear title to her own home. New York. New York probate costs typically run 3% to 7% of the estate's total value. For a $500,000 estate, that's $15,000 to $35,000 in total expenses. Attorney fees in New York City run $350 to $600 per hour, among the highest in the country. And unlike California, there is no statutory cap. The meter runs until the case closes. New York also has its own state estate tax. Estates over approximately $6.94 million are subject to New York estate tax at rates up to 16%. For high net worth families in New York, this adds a significant layer of cost and complexity on top of standard probate expenses. Like Florida, New York does not offer transfer on death deeds for real estate. A living trust is the primary tool available for keeping property out of probate. Court filing fees range from $45 for small estates to $1,250 for larger ones. The overall timeline runs 6 months to well over a year for contested or complex estates. So what can families in these 3 states actually do? The answer is the same in all 3, but the urgency is higher. Step 1. If you live in California, Florida, or New York, and you own a home, a living trust is not optional. It is the primary tool for keeping your real estate out of probate in all 3 states. Without it, your home goes through the full probate process, triggering the statutory fees, the court timeline, and the public record. Step 2. For bank accounts and investment accounts, add POD and TOD designations immediately. Payable on death for bank accounts, transfer on death for brokerage accounts. These designations are free, take 10 minutes, and allow those accounts to pass directly to your beneficiaries, completely outside of probate, regardless of which state you live in. Step 3. For California residents specifically, if your estate is under $208,850, you may qualify for a small estate affidavit. This simplified process avoids full probate entirely. Check with your bank or a local attorney to confirm eligibility. Step 4. For Florida residents, check your home ownership structure. If your home is jointly owned with your spouse with right of survivorship, it passes automatically outside probate. If it's in your name alone, it goes through probate. A living trust or a ladybird deed, also called an enhanced life estate deed, can transfer your home outside probate in Florida without giving up control during your lifetime. Step 5. For New York residents, given the combination of high attorney fees, no TODs for real estate, and the state estate tax, a comprehensive estate plan, reviewed by a New York estate planning attorney, is the most important investment you can make. The cost of planning is a fraction of the cost of not planning. Let me bring this together. Probate is not just paperwork. It is a court process that takes months, costs thousands, becomes public record, and happens to your family at the worst possible moment, when they are grieving and least equipped to deal with it. In California, it can cost $46,000 on a $1 million estate, calculated on gross value, not equity. In Florida, it freezes assets for up to 18 months and costs up to 8% of everything you own. In New York, attorney fees run $350 to $600 an hour, with no cap and no end date in sight, and every one of these costs is avoidable with the right planning. The three tools that work in all three states: a funded living trust for your home and major assets, POD and TOD designations on every account, and a pour-over will as a safety net. Together, they keep your family out of court entirely. Next week, I'll show you the most powerful tool to keep your family out of probate court. It's called a living trust, and most people have no idea how it works. If you like this video, like and subscribe. It helps more families find this content.